Good morning. This is your Kelso Report for Monday, January 9th, and I'm your host, Clark Kelso. We have 4 cases to review today. First, a case involving appellate procedure and the doctrine of mootness. Under Article 3 of the United States Constitution, federal courts may hear only cases or controversies, and when a case no longer presents an actual dispute between the parties, the federal court's obligation is to dismiss the action, whether in the trial court or on appeal. That is what the Ninth Circuit did in Vegas Diamond Properties versus FDIC, where a TRO forbidding a trustee's sale of property had been dissolved by the trial court when a failing bank was taken over by the FDIC as receiver. Although there was an interlocutory appeal of the order dissolving the TRO, while the case was pending review on appeal, the property was actually sold to a bona fide purchaser for value. Since there was no way of undoing that transaction, the case was clearly moot. Although the parties seemed to desire the court to decide the appeal anyway, arguably under the capable of repetition yet evading review exception, the Ninth Circuit dismissed the appeal, noting that, unlike a state court, a federal court cannot decide a case that has truly become moot simply because the issue is one of potential public interest. As the panel noted, federal courts are limited by the case or controversy requirement of Article 3 to adjudication of actual disputes between the parties. Our next case arises in the area of criminal law, the interpretation of the word person. Now, the word person, when used in statutes, quite commonly includes both natural persons and artificial persons, such as corporations and partnerships. Well, Section 876C of Title 18 of the United States Code makes it a felony to mail a communication, quote, addressed to any other person and containing any threat to kidnap any person or any threat to injure the person of the addressee or of another, close quote. The question before the in-bank panel of the Ninth Circuit in United States versus Havelock was whether the word person in Section 876C referred only to natural persons or also included corporations. Now, there actually is something in Title I of the United States Code called the Dictionary Act, which provides definitions for a number of common statutory terms that courts are to apply unless the context dictates otherwise. Person is one of the words in the Dictionary Act, and it is defined to include artificial persons. But in the case of Section 876C, a majority of the in-bank concluded that the context of the language in the statute indicated that it referred only to natural persons. In particular, the word person was used more than 12 times in Section 876, and in many of those uses, it really made sense only as applied to natural persons. For example, release of any kidnapped person, any threat to kidnap any person, or any threat to injure the person of the addressee or another. The reputation of a deceased person. As the majority noted, you don't kidnap corporations or injure the person of a corporation or talk about a deceased corporation. And since Congress used the word person throughout the section without any expressed intention to adopt 2 different definitions, the majority concluded that the word person throughout the section should be given the narrower definition, which limits it just to natural persons. Now, it seems to me this is a pretty close case. And as the majority notes in its opening paragraph, quoting the great Felix Frankfurter, in matters of statutory construction, it makes a great deal of difference whether you start with an answer or with a problem. Although it's a close case, I doubt the Supreme Court will take this one up. It's just not that important. So for the foreseeable future, Section 876C applies only to natural persons. Our next case arises as criminal sentencing under state law. Now, Section 3003, Subdivision F of the Penal Code is California's residence restriction statute, which limits a parolee convicted of certain enumerated felonies from living within 35 miles, quote, of the actual residence of a victim of or a witness to, close quote, one of the enumerated felonies. The petitioner had been convicted of second-degree murder for killing 2 people while driving under the influence of a drug. When he was paroled, the sister of one of the victims asked the Department of Corrections and Rehabilitation to impose a condition restricting the petitioner from living within 35 miles of her, a request the department granted. In In re Terrence Renee David, the 2nd District granted the petitioner's request for a writ of habeas corpus and held that the residence restriction was unlawful, because Section 3003F does not apply to the sister or other family member of a victim. Instead, it applies only to victims and witnesses of the specified crimes. Now, it may be that certain other victims' rights statutes do provide protections to other family members, but the court held that the word victim, standing alone, does not have that broad meaning. And our last case this morning is an insurance law action. Now, there is a general difference in remedies between equitable contribution and equitable subrogation. Subrogation involves situations where one person steps into the shoes of another person's rights or obligations. Equitable contribution, by contrast, involves a situation where one co-obligor or joint obligor seeks a fair share from other co-obligors or joint obligors. Another difference is that there is a 2-year limitation period on claims for equitable contribution, but a 4-year limitation period on claims for equitable subrogation. As you might imagine, a person with a claim for equitable contribution who misses the 2-year limitation period is going to try to reframe their complaint as one for equitable subrogation. And that is exactly what the insurance company tried to do in American States Insurance versus National Fire Insurance Company of Hartford, where one insurance company wanted to collect against another company, claiming that their insurance policies overlapped on certain claims and that the other company was therefore jointly liable. But, having failed to file for equitable contribution within the 2-year limitation period, the company tried to claim that its complaint actually was for equitable subrogation. Well, the 4th Appellate District didn't buy it, and held that its contribution claim was time-barred and its subrogation claim did not exist. Game, set, and match. That's it for today's Kelso Report. Have a great day in the law.